National Housing Development Fund was put into law through the Finance Act in 2018 of July, and its intention was to create a fund through which low-income earners can have easy access to mortgages to obtain homes. There are quite a number of issues that have not been properly addressed in the fund. One is in relation to the fact that everybody who's an employee is contributing to the fund, but it's not clear how everybody is going to benefit from the fund. As I said, it's geared towards low-income earners, and not all employees are low-income earners. Secondly, of course, is the issue of a higher wage bill for employers at a time at which they are going through quite a difficult financial downturn. I think the third thing which is important to mention, because in Kenya we do have a number of foreign employees, there is no exception to their contribution, and neither is there any clarity on whether they can benefit from the mortgages that the fund is seeking to give out.
Outside of the Constitution, there is no other legislation that deals specifically with data protection. And the purpose of the Data Protection Bill is to actually add flesh to the constitutional right to data privacy. Various companies within our society collect data and have data on individuals. So, for example, medical information, or information relating to trade union membership, or personal information that is collected by an insurance company. The impact of the bill is to ensure that those entities are not able to just freely use that data without certain restrictions and without following certain requirements that are spelled out in the law. Fly 540 essentially terminated the employment of a country manager for their Ugandan operations. And the country manager, Jacqueline, essentially claimed that she had not been treated properly in the process. So, for example, what she claimed was that when she was told to get on a plane and meet with the employer, she had been given no prior notice of the reasons for the meeting or what the allegations against her were. So from her point of view as an employee, she had no chance to prepare.
In relation to disciplinary matters, employers need to be very careful, because in Kenya we have a very employee-friendly jurisdiction. And there are two key things that you have to consider. You have to consider fair reason and fair process. In this case, the employer thought they had a good reason, but they didn't follow the right process for the reasons that they gave in conducting the meeting itself. The issues on who attends the meeting, how the employees called for that meeting are also very pertinent and played a big role in the fact that this employer was found culpable for wrongful dismissal. Barclays was winding up its Africa regional office in Nairobi. And what happened is one day the employer had a meeting with the employees and informed them that they were closing down the office. Thereafter, each employee was given an individual letter and told of their termination.
When an employer wishes to make employees redundant, there is a legal obligation on the employer to consult. Now, that obligation to consult is not actually set out in the Employment Act itself, but the aspect of consultation has come about through case law. And what is certainly interesting for us as practitioners to note is that this decision once again reiterates the need to consult in order for the redundancy process to be free and fair.